Good afternoon, everybody. Good afternoon. We're going to try and get started. We have a very, very full agenda today at our Access to Justice in the Federal Courts Symposium. Welcome. I'm Caroline Fredriksen. I'm the Executive Director of the American Constitution Society for Law and Policy. ACS, as many of you know, is a national network of lawyers, judges, law professors, policymakers, and law students that promotes the vitality of the Constitution and the fundamental values it expresses: individual rights and liberties, genuine equality, access to justice, democracy, and rule of law. We have an outstanding program for you today. We are so pleased to bring to you today's distinguished keynote speaker and two panels of our most distinguished litigators, scholars, and advocates who will explore critical issues about the ability to vindicate rights in federal court. Recent Supreme Court and federal court decisions have restricted access to the federal courts and limited the types of claims and relief that plaintiffs can pursue. These changes are significant because they have erected new barriers to keep victims of unlawful conduct out of court and offer additional protections to parties who have harmed them. These changes cast serious doubt on our core beliefs that every person is entitled to his or her day in court, to a jury of his or her peers, and to receive due process of law. Today's program will explore these and many, many other issues. Starting off today's program, it is my very sincere pleasure to introduce our keynote speaker, my dear friend, Anthony Romero, the Executive Director of the American Civil Liberties Union. Now, I'm not going to go into Anthony's background. We have biographies for you in the materials you have, but I think you will all understand how there could not be a better person to start off today's discussion. For the past 8 years, Anthony has been the leader of an organization that has been devoted to defending liberty and individual freedom in the United States. Under Anthony's leadership, the ACLU has dramatically expanded its groundbreaking litigation throughout the nation. There's really not a single day you can't pick up the New York Times or another major newspaper and read about the ACLU in the courts and Congress. I'd also like to mention, because I was the legislative director there, but really the courts is what we're here to talk about today. Anthony and the lawyers at the ACLU know that the importance of being able to go into the court to vindicate your rights when there are no other alternatives and other checks and balances have failed. So we are especially glad to have him here today to talk about how these recent court decisions are affecting our rights and what we can all do to make sure that the courthouse doors remain open for everyone. So please join me in welcoming Anthony Romero.
I have to say that when I got the call from Caroline to come and present this keynote address, I was looking for every excuse not to do it. Life's been a little bit busy. We're on the one-year anniversary of the Obama administration. I love the American Constitution Society, and yet I lament Caroline's departure every day when she left us to join you. But I really can't tell you just how thrilled I am to be here and to join you in this discussion. It is remarkable to think about how the ACS, in its short lifespan, has begun to change the American legal landscape. It's my hope that this won't be the last time an ACLU lawyer speaks before you. Given the Obama administration's great affection for ACS attorneys, including our friend Eric Holder and Lisa Brown, there's an excellent chance that someone affiliated with your organization will be in front of someone from our organization where we argue a case. And so the chance of opening a rapport with you now before the separation of the black robe and the elevated status of the judiciary, it's a good time for us to begin to open up a line of rapport. The subject today is access to justice. But my fear is that the attacks on access to justice, with which you are rightly concerned, are in fact just the most evident signs of a larger attack on the federal judiciary. I believe that there is a significant effort underway and a lot of momentum to limit the power of the federal bench and to fill that void with economically powerful institutions which are often unsympathetic to civil liberties, individual rights, and equality of opportunity. Limiting access to justice is simply the first step in changing, or rather outflanking, the justice system outright. We all know that a strong and active federal judiciary is fundamental to the protection of our liberties, the workings of our government, and the integrity of our economy. It stands as more or less the only impartial arbiter among and between the desires of powerful institutions inside and outside of government, between the rights of individuals and groups, and between the politics and prejudices of the moment. Confidence in the judiciary is vital to its working. When people are confident in the judiciary, our elected officials are less tempted to seize jurisdiction and politicize important decisions. And when controversial decisions are handed down, a people with a confidence in the judiciary are more inclined to grudgingly accept them, even though they may personally disagree. A strong judiciary brings stability, progress, and is central to the kinds of checks and balances that our founders envisioned. In a nation as passionately divided as America is today, confidence in the judiciary is extraordinarily important. But in order to maintain that confidence, to maintain the balance our society needs, it's important that when individual Americans believe that they have a right to challenge wrongdoings and have access to the court, that indeed is the fact. We cannot move forward as a nation unless you and I and the other 300 million Americans believe that we have a legitimate and open avenue of redress when we have been wronged. No one knows this better than my colleagues at the ACLU, that access to justice is an absolute prerequisite to justice itself. And that's why we are so alarmed at recent attempts to limit access by attacking plaintiffs' and defendants' standing, by limiting discovery rights, curtailing the court's jurisdiction, attacks that may seem obscure to the general public, but which are in fact very serious attacks, not only on individual liberties, but on the legal system itself. Worse yet, attacks on the courts and attacks on individual access to the courts reinforce each other. Diminished access to the court system means diminished confidence in it. And diminished confidence in the court system emboldens other institutions to seize jurisdictions from the courts. It's not a coincidence when you reflect on the fact that George Bush launched his campaign to limit the powers of the federal bench, and by doing so, by withering attacks on so-called activist judges. A public convinced that the federal judiciary was infested with liberal activists supported by a criminal lobby, some would say the ACLU, they would think that it's more likely to look the other way when a president attempts to trample on the Constitution. Compounding this problem is that when judicial oversight is itself weakened, other institutions are strengthened and are better able to pursue their own interests, whether or not they're aligned with justice. A government agency may be able to protect criminals in their midst, limiting the ability of a wronged party to bring suit. A large corporation may be able to routinely engage in illegal practices, confident that those whom it wrongs will lack the standing or the resources to challenge their action. We know from the laws of physics that a void created is always filled with something else. The ability of individuals to access the justice system is vital, and I'm sure we all agree that efforts to limit that access are reprehensible and unconstitutional. But I also believe that these efforts are best viewed as part of a larger context to disempower individuals and the courts who protect their rights, and to transfer power to other institutions for whom the idea of justice is a secondary consideration at best. The court system has already been weakened by systematic assault over many years. With our government in gridlock and our nation at loggerheads over many vital and difficult social, economic, and political issues, it is critical that we fight both to protect individual access to justice and the jurisdiction of our federal courts, and that both ends are pursued together. So far, our court's reputation has survived intact. At a time when 62% of Americans tell pollsters that they believe America is on the wrong track, 76% of Americans have confidence in the judicial branch of the federal government, vastly more than the number that say they have the same confidence in either the executive or legislative branches. And that number has been rising since Obama's election. This confidence is important because confidence in the legal system is fundamental to our efforts to ensure rights and to ensure that responsibilities and rewards of America are offered to every person. But there is indeed, I think, a lesson in the declining approval of the Congress and the presidency for the federal courts. Fairly or unfairly, Congress and the president are not perceived as getting the job done. If public perception begins to paint the courts with that same brush, the same decline in public approval will surely follow. And the perception that people do not have access to justice through the court system is a key driver of this dynamic. But for all the confidence that the pollsters will tell us that the public has in the courts, to me, they almost feel like their own life support. The last decade has seen systematic efforts to limit access by the executive, by the Congress, and perhaps most alarmingly, by the courts themselves. It's not news that the executive branch is eager to diminish the access to the courts in order to shift power from its own hands, from the judiciary to its own hands. For 8 years, we withered under the assaults of the Bush administration, where they sought to act unsupervised by the judiciary and invoking extraordinary powers, often invoking national security premises, the discredited theory of the unitary executive. These reasons that the courts would not be able to reach or extend to decisions made in the Oval Office or in the executive branch. What was surprising and most disappointing is the eagerness with which the Obama administration has taken the baton from the Bush administration. The upshot is an ongoing campaign to deny plaintiffs their day in court, to protect senior officials from litigation, regardless of their actions and roles. Often the administration needs a co-conspirator, and in Congress, who is more interested often in votes than in justice, they found a very pliant one. Again and again, Congress has attacked the fundamental principle of separation of powers, not only by giving their own oversight powers away, but by stripping powers from the court system and giving it to the executive branch. Inevitably, it led down a process of limiting access and assigning very broad, troubling powers to the presidency. The result, as we've seen over the last 8 years, has been entire classes of people who are denied access to justice, but who may not even be aware of the injustices to which they are subject. And then most dishearteningly, the federal courts, it seems, have been almost eager to limit access to the legal system and to emasculate itself. A series of decisions at the highest levels have often gone far out of their way to ignore precedent and even the will of Congress to chip away at access and limit their own power. These efforts, these decisions, which we'll talk about today in the panels that follow, place a tremendous burden on plaintiffs, hand a huge advantage to parties like governments or corporations with almost unlimited resources, and put the much smaller opponents in a much weaker position. Attacks on the judiciary by the Bush administration were hardly unexpected. Attacks on so-called activist judges have resonated with the conservative flank of American society since at least Brown versus Board of Education, when we saw all those bumper stickers that said, "Impeach Earl Warren." President Bush even announced his intention in advance of his taking office. He said, quote, "The voters will know I'll put competent judges on the bench, people who will strictly interpret the Constitution and will not use the bench to write social policy." But the packing of the courts with conservative jurists wasn't enough. Especially in the area of national security, the Bush administration was determined to ignore the federal bench entirely, stripping suspected terrorists of their rights in ways that have profound implications for all Americans. The list of embarrassing reversals of the Bush administration's policies that he suffered at the hand of the Supreme Court is really quite remarkable and gives us some idea of the absolute power that he sought to hold. And to punish his administration's efforts at these powers, the Supreme Court clipped their wings a bit. Remember Rasul versus Bush, where the court ruled that Guantanamo detainees did indeed have the right to challenge their detention. Consider Hamdan versus Rumsfeld, where the Supreme Court found that Bush's attempts to circumvent civilian courts by creating military tribunals was flagrantly unconstitutional. Consider also Boumediene and Al-Dada, where the federal court found that even the decider, George Bush, didn't have the power to ignore centuries of common law and deny detainees their habeas corpus rights. The High Court's commitment to undoing these extra-constitutional efforts of President Bush at times have been supported by President Obama. We have a client, Mr. Almari, a Qatarian citizen legally residing in the United States, was arrested and held in solitary confinement in a naval brig for 6 years by Bush administration officials that had classified him as an unlawful combatant. Had their classification been allowed to stand, as 2 courts ruled that it could, the president could have been empowered to classify any American citizen or legal resident as an unlawful combatant and hold them indefinitely without charges or trial, or even to try them in a military commission. The ACLU filed a habeas petition on behalf of Mr. Almari, and we were preparing for a major Supreme Court argument when the Obama administration gratefully changed course and brought criminal charges against Mr. Almari, convicting him in a federal court rather than before a bankrupt military tribunal. While we were disappointed that the Supreme Court dismissed our case as moot at that point, we were heartened to know that the administration's actions led the Supreme Court to vacate the appeals court ruling in favor of unlawful enemy combatant status. And that meant that the Bush strategy of end-running the Constitution by declaring any individual suspected of terrorist links as an unlawful combatant was effectively reversed. But for all the efforts of the Obama administration and all the high-level defeats that the Bush administration suffered before the Supreme Court, we still see, though, that some of these very dubious legal theories continue under the Obama administration. As we mark the 1-year anniversary of his assuming office, perhaps it's notable for us to take stock of where they've not gone far enough. Despite the laudable efforts to try Guantanamo detainees and to close the prison itself, the Obama administration has asserted its right to a gitmo all its own, Bagram Air Force Base in Afghanistan. Earlier this month, the Obama Justice Department urged the D.C. Court of Appeals to reverse a lower court ruling that 3 detainees being held at Bagram were not entitled to challenge their detention rights under habeas corpus. In a different piece of ACLU litigation, we are now leading the fight against the Obama administration's efforts to extend the state secrets privilege and embrace essentially the same very theories that the Bush administration put forward in saying that the government can restrict discovery and also quash an entire lawsuit without demonstrating the validity of their claims to a judge. This, unfortunately, is not our first battle with the state secrets privilege. In 2004, we filed suit against the CIA on behalf of a German citizen, Khaled El-Masri. In 2003, Mr. El-Masri was arrested, imprisoned, detained, first in Macedonia, then transferred to Iraq, in a secret location where he was tortured and interrogated by the CIA for 5 months before they discovered they had the wrong person. Eventually, the CIA realized they had the wrong man, took him back on another transport plane, dumped him on the hillside of Albania, and told him to keep walking and not look back, literally. In 2006, after Mr. al-Masri turned to us for help, we filed in court arguing that Mr. al-Masri should be allowed access to the judicial system and to seek redress for the wrongdoing done to him by CIA interrogators. A federal judge in that case dismissed our case, accepting the CIA's claim that simply holding the proceedings at all would jeopardize state secrets, and therefore denied Mr. al-Masri his only real chance for justice. Now, we're hoping to change that precedent with the earlier case I mentioned to you about the Jeppeson data plan case. Last month, 3 of our lawyers at the ACLU before the full Ninth Circuit Court of Appeals argued that another one of our clients, Binyan Mohammed, and 4 others who had been kidnapped and transported to torture sites aboard Jeppeson Data Plan, a subsidiary of the Boeing Corporation, were entitled at least to bring their action against a company which had knowingly taken part in illegal actions as a subcontractor of the CIA. 2 years ago, the trial court caved in to the Bush administration, claiming that state secrets would allow them to put an end to the entire proceedings even before we presented our facts or our side of the case. This spring, however, 3 judges from the Ninth Circuit reversed that ruling over Obama administration objections. And lamentably, just last month, we were up again in court arguing against now different Justice Department officials about why this case should even be heard and allowing our plaintiffs to present their case before their case is fully dismissed. The administration asked for a full hearing before the court, asserting that the right to crush a lawsuit against a company that was knowingly accomplice to torture was proper simply on their say-so. Now, the facts on this case are really quite remarkable. We actually have on the record one senior Jeppeson official who told an internal corporate gathering that, quote, "We do all the extraordinary rendition flights, you know, the torture flights. We would like to present that evidence in a court of law and have a judge adjudicate whether or not it is relevant and whether it would be sufficient to find findings of wrongdoing against these officials. In the United States, criminal arrogance and indifference should not go unpunished simply on the unchallenged claim by any government official, particularly when the operation that gave rise to the lawsuit had been so thoroughly and publicly exposed. People who were tortured by the American government must have a chance to gather evidence and make their case before a court of law. If not, to what utility are the courts? Sadly, the Obama administration appears in this case to be more interested in covering up the errors of its predecessors and protecting itself from possible investigation by subsequent administrations rather than injustice itself. In attempting to limit access to justice, the executive branch too often has been a willing partner with the legislative branch. We saw that first with the USA Patriot Act and continuing under the Homeland Security appropriations bills that essentially quashed a FOIA request filed by the ACLU. Congress has too often deferred to the executive branch, and for fear of political pressure and constraining access to basic justice for American citizens, they have taken us down a very wrong-headed path. Some of those most egregious outrages have been reversed. In yet another case that we brought, in Doe versus Gonzalez, we won the ability on behalf of a client that national security letters, which allow searches of library, financial, internet records, employment records, without probable cause and impose a gag order on those served, that those were in fact flagrantly unconstitutional. But despite whatever checkered successes we may have had, too many constraints remain in place, including a military commission law that institutionalizes and makes permanent unconstitutional procedures and further strips protections under the Foreign Intelligence Surveillance Act that essentially eliminates existing FISA court reviews as a system of check and balance on unlawful spying. Last fall, at the administration's request, at the Obama administration's request, Congress included a clause in the Homeland Security Appropriations Bill giving Defense Secretary Robert Gates the authority to exempt any and all photographs that he alone thought should not be released for fear of a backlash on national security, essentially reversing a Second Circuit ruling that had required the government to turn over those photographs. Again, the Obama administration seems determined to give the federal government the authority to hide evidence of the government's misconduct, even if it was not done on its watch, and to place an impenetrable wall between officials who damage our national security and international standing. And in this case, Congress is carrying their water for them as well. A vigorous democracy demands checks and balances, a Congress that teams up with the executive branch to broadly restrict the power of the judicial branch, to transfer power to other branches of government, throws the balance of power off to the long-term detriment of our democracy. And perhaps most disturbing of all has been the attack on the federal judiciary and the basic rights of individuals to have access to the court in a case that took an enormous amount of work to undo. In Ledbetter versus Goodyear, the court again found, against the obvious intent of Congress and an existing Supreme Court precedent, that action had to be brought within 180 days of the first violation of literally hundreds of discriminatory actions over 20 years. Such a standard was nothing short of absurd. It not only took the power to pursue justice away from individuals like Ms. Ledbetter, and the power to determine justice away from the courts, but it gave that power to a massive entity whose only real interest is profit. It created a void into which many employers were delighted to step in. In this case, Ms. Ledbetter became such a cause that the Supreme Court was essentially reversed by Congress and the precedent. But the elections already looming large, we have to ask ourselves, how many candidates will have the name of William Twombly or Mr. Iqbal on their lips? Twombly, as we'll explore in the next panel, was the lead plaintiff in a suit brought against regional telecommunications companies alleging anti-competitive activities in violation of the Sherman Antitrust Act, limiting competition and keeping margins high. The allegations concern virtually everyone who pays a phone bill in America. The court didn't dispute the idea that the phone company practices mimicked practices that would be adopted in the companies, and had in fact engaged in anti-competitive practices. And yet the Supreme Court found that evidence of parallel conduct by the companies was insufficient not only to convict, but to even proceed with the lawsuit. And speaking of activist judges, they did so in a way that overturned the precedent in another case of Connolly versus Gibson, that plaintiffs need only show a conceivable standard and not have to adopt a more strict plausibility standard, which was later imposed. In other words, they said you can't begin to gather evidence through discovery unless you already have enough evidence to win. The standard was further expanded beyond the realm of antitrust law in Ashcroft versus Iqbal. Mr. Iqbal was arrested and warehoused in a maximum security facility where he was brutally treated, denied access to counsel, and prevented from praying by guards who suspected him of being a terrorist. Mr. Iqbal sought suit with the help of the Center for Constitutional Rights and other groups, and they brought forward a suit claiming that purposeful and lawful discrimination sprung directly from the policies put in place by FBI Director Robert Mueller and Attorney General John Ashcroft. In response to a motion to dismiss, a lower court allowed the suit to go forward, but the Supreme Court demanded that Iqbal clear the new higher bar set by Twombly and acted to protect senior government officials, dismissing the case for lack of evidence in the initial pleading. Now, taken together, these two cases impose on plaintiffs the Herculean task of proving their case before it's even heard. And it makes justice more difficult to achieve for individuals when it transfers de facto judicial power to the most powerful institutions in America, massive corporations and the federal government. Name that tune. Large corporations are not led by any stretch they're not by any stretch inevitably wrong or evil or avaricious. But by design and instinct, justice is not their first priority. Profit and power is. That works out well if there is an independent, equally powerful institution whose first priority is indeed justice. But it is a recipe for disaster if there is no check on their behavior and restraints on their baser instincts. There is, finally, another obstacle to securing access to justice, one thrown into sharp relief by the results of the Massachusetts special election last Tuesday, and one which may be the most alarming obstacle of all, the simple lack of sitting judges to hear cases. According to another one of our sister organizations, the Alliance for Justice, there are now 101 federal court vacancies, 80 in the district courts, 21 in the courts of appeal. In his first year of office, Mr. Obama has anemically secured only 13 confirmations, with 19 others pending. That scorecard is shameful when put up against the scorecards of George Bush, who had won double those confirmations in his first year, and even those of President Clinton, who won 50% more in his first year. Both ends of Pennsylvania Avenue share the blame for this situation. The White House, clearly, for moving so slowly, and the Senate for focusing elsewhere and often throwing procedural obstacles into the nominee's path. But when earlier efforts to limit the judicial access were often bipartisan efforts to demonstrate anti-terrorism credentials to voters, efforts to slow the pace of judicial confirmations seems now to be a more partisan effort. With the Republican vote number to be 41, with the Massachusetts senator about to take his seat this month, it seems very likely that the administration will have an even harder time to push through its nominees in a hostile political environment. I don't believe there can be any greater threat to access and to justice itself than a systematic effort to starve the courts of the talented men and women they need to make the system work. In a nation riven by spectacular partisan rivalries, marked by a massive and well-earned distrust of major institutions, and beset with serious questions about civil rights and civil liberties and how we as a nation will protect and expand them, there is a tremendous need for individual access to an institution whose sole focus is to deliver justice. In this society, attacks on individual access to justice quickly become attacks on our legal system and our democracy as a whole. To the extent that they are successful, they weaken not only the courts, but the very fabric of our democracy, throwing undue influence to the wealthy and the powerful, stripping disadvantaged individuals and groups, and destroying the power balance among the government branches carefully weighted by our founding fathers. Each individual case, whether it's a case of gender discrimination or torture or the rights of non-citizens, each individual case or law is not just significant for the clients for whom it's brought. It's the cumulative effect of them that threatens to undermine the fundamental values of this nation and shift the powers in ways that cannot or should not be tolerated by any member of the bar. If we tolerate it, it will lead us inevitably to a less just and free society. Your focus on access to justice is not just laudable, but essential. To protect it, we must look beyond the individual and also act to preserve the power of the system as a whole. And that's why the formation of the American Constitution Society and your focus on these issues today are of such profound importance that I thank you for the opportunity to be with you today.